All right, the next element in libel in Chapter 4 of the Law of Journalism and Mass Communications is falsity. And this element is pretty straightforward. For the statement to be libelous, it has to be false. Now, the focus on the proof of falsity, that goes to the person who is filing the claim, so that's to the plaintiff. The burden of proof falls on the plaintiff to show that the statement that they are making a claim against is false. That is the flip of what used to be where the defendant had to prove that the statement was true. So it places the burden on the plaintiff. The idea is to protect free speech and the free flow of information and ideas. And there's a quote in the book that's actually worth a read on page 160 from former Justice Sandra Day O'Connor concerning media and journalists. We believe that the Constitution requires us to tip the scales in favor of protecting free speech. The burden of proving truth upon media defendants who publish speech of public concern deters such speech because of the fear that liability will unjustifiably result. Because such a chilling effect would be antithetical to the First Amendment's protection of true speech on matters of public concern, a plaintiff must bear the burden of showing that the speech at issue is false before recovering damages for defamation from a media defendant. To do otherwise could only result in deterrence of the speech which the Constitution makes free. So again, the burden of proof on the plaintiff to demonstrate that this was false. One other piece for the defendant. So defendants have as a defense truth, and as long as the statement was substantially true, then it's not considered false and doesn't qualify as being libelous. So minor errors, minor discrepancies, those don't make the statement false. So if there are slight inaccuracies, that does not nullify the truthfulness of the statement. At the same time, just because there are truthful statements doesn't mean that that is the truth. Putting different statements together in order to create some sort of implication or innuendo collectively, that can be seen as making false statements. So implication and innuendo, where they're connecting facts to circumstances on their own, they're truthful, but when you put them together, it creates a false impression. You don't play fast and loose with the facts and allow the readers to then connect. The textbook gives a couple of different examples where they've got a crane operator that's involved in an accident, and he has a history of drug abuse, but it's unrelated to this accident, and yet they publish that information to make it seem as if the reader would be able to draw a conclusion that the drugs may have had something to do with the accident. I think there's another one that they talk about with sex scandals with a fire department, and they have a photograph of one of the firemen, and the implication there is that this fireman is involved with that. So you need to be careful on the information that you're piecing together, and that's even if it's unintentional. Alright, so that gets us to the element of falsity. Again, elements you can find on page 150 in the textbook. A statement of fact that is published of and concerning the plaintiff, that injures the plaintiff's reputation, that is false, that caused damage or harm, and that is the result of fault by the defendant. So